Entering the world of medical malpractice law in 2026 requires a deep understanding of how a single mistake can change a life forever. When a doctor or a hospital fails to meet the accepted standard of care and causes an injury, the legal system is designed to provide compensation to the victim. This compensation is known as damages, and it is divided into two primary categories, which are economic and non-economic damages. Economic damages are the objective financial losses that come with a paper trail, such as hospital bills and lost wages, and the cost of future medical care. These are relatively straightforward to calculate because they are based on concrete numbers and expert projections of financial impact. However, the second category, known as non-economic damages, is far more subjective and emotional. These damages are designed to compensate for things that do not come with a receipt, such as pain and suffering and emotional distress, and the loss of enjoyment of life or the loss of companionship. In 2026, these non-economic damages are at the center of a massive legal debate because many states have placed strict limits or caps on how much a victim can receive regardless of the severity of the injury. The philosophy behind these caps is often rooted in what is called tort reform. Proponents of damage caps argue that without these limits, the cost of medical malpractice insurance would skyrocket and force doctors to leave certain states or quit the profession entirely. They claim that caps create a stable and predictable environment for insurance companies, which in turn keeps healthcare costs lower for everyone. On the other side of the argument are patient advocates and trial lawyers who believe that these caps are fundamentally unfair. They argue that caps punish the most severely injured victims the most, because a person who is permanently paralyzed or who loses a child is told by the law that their suffering has a maximum dollar value. As we navigate the legal landscape of 2026, we see a patchwork of laws across the United States, where your location at the time of the injury determines your access to justice. In California, the landscape has changed significantly due to recent updates to the Medical Injury Compensation Reform Act, which is commonly known as MICRA. For decades, California had a legendary $250,000 cap on non-economic damages that never adjusted for inflation. However, in 2026, we are seeing the results of a multi-year phase-in of higher limits. For medical malpractice cases in California that do not involve a wrongful death, the cap on non-economic damages has risen to $470,000 for 2026. If the malpractice resulted in a wrongful death, the cap is even higher, sitting at $650,000. These amounts are scheduled to continue increasing every year until 2033, which represents a massive victory for victims who had been restricted by the old limits for nearly 50 years. Maryland is another state that provides a specific and adjusted cap for 2026. The Maryland legislature designed their system to include an annual increase to account for the rising cost of living. For cases arising in 2026, the cap on non-economic damages for a personal injury malpractice claim is $920,000. In cases where the malpractice results in a wrongful death with 2 or more surviving family members, the cap increases to $1,130,000. It is important. Remember that these limits only apply to the non-economic portion of the award, and there is no limit on how much a victim can recover for their actual medical bills or their lost income. North Carolina has also updated its limits for the current year. As of January 1st, 2026, the liability limit for non-economic damages in medical malpractice cases has been set at $712,847. This represents a significant increase from previous years and is adjusted periodically based on the Consumer Price Index. North Carolina is a prime example of a state that tries to balance protection of its medical community with the needs of injured patients by allowing the cap to grow with inflation rather than letting it stagnate. Colorado is currently in the middle of a major transition regarding its tort laws. In 2024 and 2025, the state legislature passed and the governor signed laws to significantly raise the damage limits. For 2026, the cap on non-economic damages in most medical malpractice cases is moving toward a target of $875,000, which will be fully phased in over the next few years. Furthermore, Colorado recently raised its wrongful death cap to $1.5 million, acknowledging the profound emotional impact of losing a loved one. This shift in Colorado is part of a broader national trend where states that previously had very low caps are beginning to realize that those limits no longer reflect the economic reality of 2026. While many states only cap non-economic damages, there is a group of 6 states that enforce what is known as a total cap. In these states, the law limits the entire recovery, including both economic and non-economic damages. These states include Colorado, and Indiana, and Louisiana, and Nebraska, and New Mexico, and Virginia. For example, in Virginia, the total recovery for all damages rising from a single act of malpractice is strictly limited by a schedule that increases slightly each year. In 2026, the Virginia total cap is approximately $3 million. This means that even if a victim has $10 million in actual medical bills, they are legally prohibited from recovering more than the state-mandated total cap. This is often seen as the most restrictive form of malpractice law because it can leave victims without enough money to even cover their basic health care needs. On the opposite end of the spectrum are the states that have no caps at all on non-economic damages. States like Pennsylvania and New York and Washington and Georgia allow a jury to decide the full value of a person's suffering without any arbitrary legislative interference. In many of these states, the highest courts have ruled that damage caps are unconstitutional because they violate the right to a trial by jury or the principle of equal protection under the law. For instance, in Florida and Illinois, the state Supreme Courts struck down previous caps because they determined that the laws unfairly targeted the most catastrophically injured people. In these states, a victim of a surgical error or a misdiagnosis can receive a multi-million-dollar award for their pain and suffering if a jury believes it is justified. Mississippi and Montana remain among the states with the most rigid limits. Mississippi maintains a $500,000 cap on non-economic damages for medical malpractice, which has faced numerous legal challenges, but remains the law of the land in 2026. Montana has an even lower cap of $250,000, which is one of the lowest in the country. In these states, the potential for a high recovery is very limited, which often makes it difficult for victims to find a lawyer to take their case because the cost of hiring medical experts and litigating a complex malpractice suit can easily consume a large portion of the potential award. Understanding how these caps are calculated is also vital for anyone involved in a lawsuit. Lawyers often use 2 primary methods, which are the multiplier method and the per diem method. The multiplier method takes the total economic damages and multiplies them by a number between 1 and 5 depending on the severity of the suffering. The per diem method assigns a specific dollar value to every day the victim has to live with their injury. However, in a state with a cap, it does not matter how high these calculations go because the final judgment will be reached by the judge to fit within the legal limit. As we move through 2026, It is clear that the battle over medical malpractice caps is far from over. There is a constant push and pull between the medical lobby, which wants to protect the healthcare system from large payouts, and the patient advocacy groups, who want to ensure that victims are fully compensated. Some states are moving toward a middle ground by creating special funds to pay for damages that exceed a certain amount, while others are sticking to their strict legislative limits. For a high net worth individual or someone with a complex medical history, knowing the laws of your specific state is the first step in protecting your rights. When you look at the big picture for 2026,